Hello, welcome back to Legal Brain. Today, I'm going to discuss yet another important topic, and that is lapse of offer or termination of an offer. So, what do you mean by lapse of offer or termination of an offer? Which means cancellation of an offer which is already given by the offeror to the offeree. For example, the offerer has given an offer and now he has changed his mind, or due to certain circumstances, he wants to cancel the offer which is given to the offeree. So, how it is possible? So, by virtue of Section 6 of Indian Contract Act 1872, we can actually cancel or terminate the offer which is given by the offerer to the offeree. So, in this class, I'm going to discuss about the different, circumstances or the conditions in which we can actually cancel an offer which is already given to the other party. So, look into the screen and try to understand. The first one is by communication of notice of revocation or notice of termination, cancellation of the offer. So how it is possible? It is possible by an offer may be revoked at any time before the letter of acceptance is posted by the offeree. For example, I am the offerer and I have given an offer to the offeree. And before the offeree sending me or communicating me the acceptance, I have time to cancel the offer that I have given to the offeree. So that can be possible by communication of the notice of termination or revocation of the offer. So that is the first mode of revocation of the offer. And the second one is by lapse of time. And that means, for example, like I have given an offer, I am the offerer and I have given an offer to the offeree, to you. And I have clearly specified that you have to communicate your acceptance within 10 days of time. I have stipulated a time period of 10 days. And now, after the 10th day, that means on 11th day, there is no offer for you to accept. So that means the offer will get automatically lapsed after the period of time. The offer will comes to an end. The offer will get automatically cancelled after the lapse of time. So the meaning is that if a time is prescribed in an offer for the acceptance by the offeree, the offer terminates by lapse of time. And if it is not accepted within the reasonable or the stipulated time, it will come to an end. So that means reasonable time meaning is if the offerer is not specified, he has not specified a specific time limit, he has not specified a stipulated time, then the offeree have to accept the offer within a reasonable time period according to the logical understanding. So that is the second point. The third one is by not fulfillment of a condition precedent. So condition precedent means a condition before. Precedent, that means a before. So what is the meaning of that? Which says that, imagine an offerer, myself, I'm the offerer, I have given you an offer, and I have stipulated a condition precedent that, the offerer is giving a condition to the offeree that you have to fulfill this particular offer. And for example, if you haven't fulfilled the particular condition precedent, there will be a lapse of offer. For example, it can be like I have given you an offer regarding the sale of my apartment, and I have specified a condition precedent stating that you have to give me an advance amount of like 50,000 rupees for this transaction. So if you are not fulfilling the condition precedent, that means, if you are not giving me the advance amount, then there will be the lapse of offer. So it says that an offer lapses or terminates if the offeree fails to fulfill a condition precedent. That is the third method. And the fourth one is by death or insanity. So death or insanity is an option that will lead to the termination of an offer or cancellation of an offer which is given by the offerer. So how it is possible? So this says that the death or an insanity of the offerer puts an end to the offer. So again, there is a difference in English law and Indian law. So I'm going to discuss about a case law which is very important falling under this particular concept, and that is Dickinsons versus Dodds. So this is an English case, a landmark decision in which the English court held that the death of the proposer puts an end to the offer, and an acceptance, though in ignorance, will not result in a contract. So even though if you are, for example, According to English law, if one person, the offerer, has given an offer, and for example, he met with an accident and he died, or he is now insane. If that is the situation, then the particular offer will get lapsed. There will be an end of the particular offer which is given by the offerer, and an acceptance, even though in ignorance, will not result in a contract, and there will be no contract even though if the offerer is giving the acceptance in ignorance of the death or insanity of the offerer. So this is the situation in England under English law. And now I'm going to speak about Indian law. In Indian law, there is a difference, and in India, the law is different, and the offer lapses only if the fact of death or insanity is brought to the knowledge of the acceptor. So if it is not brought to the knowledge of the acceptor, then if the offeree accepts the offer in ignorance of the death or insanity of the offerer, the acceptance is valid in nature. So there is a change or a difference in English law and Indian law when it comes to this particular ground regarding lapse of offer, that is by death or insanity. In English law, the death or insanity will put to an end to the particular offer, and there will be no contract. But in India, if the fact of the death or insanity is brought to the knowledge of the acceptor before the acceptance, then only there will be an end to the offer. And if the offeree accepts the offer in ignorance of the death or insanity of the offerer, the acceptance is still valid and it binds the estate of the deceased. So this is a very important case law falling under this particular concept. And the next one is by counter offer. So I have already discussed many times in the class that if there is an offer, for example, original initial offer, one person is giving an original initial offer, and the other person, the offeree, is giving a counter offer to that, there will be no more initial offer. The initial offer will come to an end. So if an offer terminates or lapses, if the counter offer is made to that. So that is the fifth point. So these are the different points which speaks about, which is falling under by virtue of Section 6 of Indian Contract Act, and speaks about lapse of offer or termination of an offer. So I hope it's clear for everybody. If you have any doubt, do comment below. And thank you for listening to me, and follow Legal Brain for more classes of contract. Thank you. Thank you so much.